Welcome back to the deep dive. Today we're tackling something that really hits home for everyone. The basic need for a secure place to live and, what happens when that's threatened.
It's fundamental.
Exactly. Think about someone like, let's call her Sarah, a farm worker, lived on the same land for decades, maybe her whole life, suddenly facing eviction. Where does she go? That's the human side of South Africa's Extension of Security of Tenure Act, 1997.
That's the reality it addresses.
So our mission for you today is to really unpack this act, make it clear, make it engaging. We'll look at why it exists, its main parts, the legal background.
The practical side, too.
Right, the practical implications and what it actually means in the real world. Whether you're just curious or maybe you're a law student grappling with this stuff, we want you to leave with a clearer understanding.
Okay, so in immediate context, it's Act 62 of 1997. Signed into law November 19th, 1997, started just 9 days later. But, and this is key, it's not frozen in time.
It's been updated.
Oh, yes. Frequently, it's a living law. The last big changes were actually quite recent, April 1st, 2024. It has to evolve because the situations on the ground evolve.
So why did they need this act in the first place? What was the problem it was trying to fix?
Well, the Act's own introduction, the preamble, tells you straight up. It says, many South Africans just don't have secure tenure. Their homes, the land they use, it's precarious.
Leaving them vulnerable.
Incredibly vulnerable. Vulnerable to unfair eviction. And the Act explicitly says this is a legacy, a direct result of past discriminatory laws. It caused, and still causes, huge hardship, instability.
So it's about correcting history, in a way.
Definitely. But it's not just about saying eviction bad. It sets out clear goals. It wants occupiers, landowners, and the government to work together.
Proactively, not just reacting.
Exactly. To build long-term security. It wants to boost occupiers' rights, but also, importantly, respect the landowner's legitimate interests. And yes, regulate evictions so they're fair, acknowledging an owner can apply to court. But the bottom line is protecting occupiers from being further prejudiced. It's a real balancing act.
Okay, let's get into the nitty-gritty then. Before we talk protections, who exactly are we talking about? Who is an occupier under this act? These definitions seem foundational.
Absolutely critical.
Yeah.
So an occupier is someone living on land owned by someone else who had permission, consent, or some other legal right to be there on or after February 4th, 1997. That date's important.
Are there exceptions?
Yes, quite a few. It generally doesn't cover land used mainly for industry, mining, or big commercial ventures. But crucially, it does cover someone who maybe works the land themselves, a small farmer, not employing others outside their family.
Okay.
And another big one. It generally excludes people earning above a certain income level. The focus is really on those who are more vulnerable.
Got it. And then there's the owner and the person in charge. If Sarah got permission from the farm manager, not the actual owner, does that still count?
Yes, it does. Consent from either the owner or the person in charge is binding under the Act. That avoids tricky situations where the owner isn't directly involved day to day.
And eviction. Seems obvious, but I bet the Act defines it carefully.
Very carefully and broadly. It's not just being physically thrown out.
Right.
It's depriving someone, against their will, of their residence or their use of the land, or even access to water connected to where they live.
Water, too. Wow.
Yes, it really covers the essentials of living there, shows how protective the scope is intended to be.
And for Sarah, that permission, that consent, whether it was spoken or just understood, that's the bedrock of her right to be there.
That's the foundation, express or tacit consent. And there's a helpful presumption, too, for civil cases. If you've lived somewhere openly and continuously for a whole year, the Act presumes you had consent.
Shifts the burden of proof, then.
Exactly. The landowner would have to prove you didn't have consent. It's a significant protection.
Okay, other key terms. What if, sadly, an eviction does happen? The Act mentions suitable alternative accommodation. What does suitable really mean? It can't just be a shack somewhere, surely.
No, absolutely not. Suitable is a high bar. It has to be safe, first off, and generally not less favorable than where they were living. It has to consider their needs, residential space, yes, but also land for farming, if that's what they did.
And practical things like jobs.
Yes, the needs of the whole household, their ability to earn a living together, and, crucially, proximity to work or schools. It's a holistic look at finding a genuinely suitable alternative.
The definitions of family and dependent also got updated. Why was that?
That 2018 update broadened things. Family now clearly includes spouses in customary marriages, kids, grandkids, parents, grandparents, if they depend on the occupier and live there. Dependent means someone the occupier has a legal duty to support.
So it reflects real family structures better.
Precisely. It focuses on the whole household unit, the collective security, which is often the reality, especially in rural areas.
And then there's this one definition that really jumped out at me. Established practice. Tell us about that.
Ah, yes. That's quite specific and culturally very important. It refers to a situation where there's a routine and established practice of the owner allowing residents to bury deceased family members on the land, according to their beliefs.
Wow. So the Act protects that too.
It does. It shows the act goes beyond just shelter. It acknowledges and protects deep cultural and ancestral connections to the land. It's quite profound, actually.
It really is. Okay, so we have the definitions, but the Act does more than just define terms, right? It sets out actual rights, fundamental rights.
Yes, Chapter 3 lays these out. It says occupiers, owners, persons in charge, everyone involved has rights like human dignity, freedom, security, privacy, freedom of religion, expression, association, movement, all subject to reasonable limits and grounded in the Constitution, of course.
So for Sarah, our farm worker, what are her specific rights as an occupier under Section 6?
Okay, Section 6 is key. She has the right to continue residing on and using the land she was on from February 4th, 1997, plus access to agreed services, a general right to security of tenure.
What about visitors? Can the owner just say no visitors?
No. She has the right to receive bona fide visitors at reasonable times. The owner can set reasonable conditions for safety or to prevent disruption, but can't just ban them. She also has the right to get mail and, importantly, the right to family life.
And that burial right we talked about.
Yes, that's in Section 6 too. The right to bury a deceased family member, if that established practice exists. And for certain long-term occupiers, their family has the right to bury them on the land when they pass away.
That's huge.
It is. Plus the right to maintain her home and, crucially, rights not to be denied access to essentials like water, schools, or health services.
Rights come with duties, though. What are the occupier's responsibilities?
Fair point. Section 6.3 lists them. Basically, don't intentionally harm others on the land, don't cause significant damage to property, don't intimidate people, and don't help unauthorized people set up new homes there. It's about respect for others and the property.
And the owner. Rights and duties.
Owners have rights too, like impounding trespassing animals, but they have to give 72 hours notice first. And a really critical duty. They must not prejudice an occupier just because the occupier exercise their legal rights under this act.
Yeah.
No retaliation.
That's a strong protection. Okay, let's get to the core issue for many people. Eviction. This is where the Act really flexes its muscles, right? It makes eviction difficult.
Extremely difficult, and rightly so given the history. For Sarah, the act is like a shield. Her right to reside can only be ended on a lawful ground. And importantly, the termination itself must be just and equitable.
Just and equitable. What does the court look at to decide that?
A whole list of things. Was the agreement fair? How did everyone behave? What's the balance of hardship? Who suffers more if she stays versus if she leaves? Did she reasonably expect the agreement to continue? And was the procedure fair? Did she get a chance to state her case?
And for someone like Sarah, maybe she's lived there 30 years, she's over 60. Are there extra protections?
Yes, absolutely. Section 8.4 provides powerful protection for long-term occupiers. If you've lived there 10 years and you're over 60, or you're an employee or ex-employee who can't work anymore due to illness, injury, or disability, then your right of residence generally cannot be terminated, period. Unless, and this is a high bar, you commit a serious breach, like deliberately harming someone or causing major damage.
What about just refusing to work if the job ends?
Crucially, the Act specifically says that refusing or failing to provide labor is not considered such a breach. That protects people from being evicted just because their employment relationship ended, especially if they're older or unwell.
So termination is hard. And then getting an actual eviction order, that's another hurdle. It always needs a court order.
Always. Section 9 is crystal clear. An occupier can only be evicted through an order from a competent court issued under this act. No self-help evictions.
And legal help. What if Sarah can't afford a lawyer?
Another vital safeguard in Section 9. The court generally can't grant an eviction order unless the occupier had legal representation during the proceedings.
Really?
Yes, unless they specifically chose not to have it, and the court is satisfied that not having a lawyer wouldn't lead to injustice. It embeds legal aid right into the process.
Okay, so the owner has terminated the right of residence lawfully. Sarah hasn't left. What does the owner need to do to get that court order? Is there a notice period?
Yes, a very specific one. Before even applying to the court, the owner has to give at least 2 calendar months written notice.
2 months.
2 full calendar months. And not just to the occupier, also to the local municipality and to the provincial office of the Department of Rural Development and Land Reform.
So multiple parties are alerted.
Exactly. It brings in oversight and potential support mechanisms. It's designed to prevent sudden, unprepared evictions.
And what does the court have to consider before granting the order? You mentioned something surprising earlier.
Right, Section 9.3. This is crucial. The court must request a report, usually from a probation officer or similar official.
A report on what?
On things like, is there suitable alternative accommodation available? What would the impact be on the occupier's constitutional rights? Think about children's education, for example. And generally, would the eviction cause undue hardship? The court needs this information to make a just decision.
It forces a focus on the human consequences.
Absolutely. It's not just a property dispute, it's about people's lives. The Act distinguishes slightly between occupiers who were there before Feb 4, 1997, Section 10, and those who came after, Section 11, but fairness and considering alternative accommodation remain key for both.
So let's say the court does grant the eviction. Does it just say, get out? Or does it manage the process? You mentioned weather.
Yes, even the weather. Section 12 is about the specifics. The court has to set a date to vacate that's just and equitable. Then a date when the order can be enforced if they haven't left. And yes, it must set reasonable weather conditions for the eviction.
No evictions in pouring rain or freezing cold.
That's the idea. It reflects a concern for basic human dignity even in that difficult moment. The court can also adjust the terms. And critically, an order can't be granted if the owner's real goal is just to stop the occupier getting those long-term Section 8.4 rights.
What about compensation? If Sarah built an extra room or planted crops, does she lose all that?
No, Section 13 covers compensation. If an eviction is ordered, the owner must pay the occupier fair compensation for structures they built, improvements they made, and any standing crops they planted, unless they agreed otherwise in writing.
And they have to pay before the eviction?
Generally, yes. The eviction order can't be carried out until the compensation is paid, or at least guaranteed to the court's satisfaction. It ensures the occupier isn't left completely empty-handed after potentially investing years of labor and resources.
Okay, so the Act is strong on preventing unfair evictions. But does it do anything proactively to help people get secure tenure in the first place?
Yes, it does. That's where Chapter 2 on tenure grants comes in. The minister can actually provide government grants.
Grants for what?
For several things. To help plan and set up on-site or off-site developments, basically, ways for occupiers to get their own independent tenure rights, either where they are or somewhere else. Grants can also help occupiers buy land, or land rights, or develop the land they currently occupy, or acquire that suitable alternative accommodation we talked about.
Can owners get grants too?
Interestingly, yes. Grants can compensate owners for providing accommodation or services to occupiers. It encourages cooperation.
How does the government decide who gets these grants? Is it first come, first served?
No, there's a prioritization process. They look at things like, does the plan involve both the owner and occupier agreeing? Is it cost effective? Have they already tried to work something out? Is it urgent because of a pending eviction? It aims to be strategic.
And then there are these newer bodies, the Land Rights Management Board and committees added in 2018. What do they do?
That was a significant addition, Chapter IVA. The National Land Rights Management Board, or LRMB, advises the minister, oversees the local committees, keeps a database of disputes and evictions, helps with mediation and arbitration, shares information, and helps people get legal aid.
And the local ones, the LRMCs?
They're more hands-on. They identify land for settlement, help get municipal services connected, try to spot and resolve disputes locally, referring tougher cases up to the board, and help gather data for that national database.
So it's building an infrastructure for support and resolution, not just relying on courts.
Exactly. It's a move towards more institutional support, more proactive problem solving, trying to resolve things before they escalate to full-blown court battles.
Okay, so when disputes do end up in the legal system, where do they go? You mentioned magistrates' courts.
Primarily, yes. Magistrates' courts handle most eviction cases, reinstatement applications, and any criminal charges under the Act. They can issue interdicts and declaratory orders too.
But appeals go somewhere else.
Yes, civil appeals under this Act go to Land Claims Court. Which brings us to an important point, especially for law students listening.
Something's changing.
There's a major change pending. The Land Court Act of 2023 hasn't commenced yet. But when it does, the Land Claims Court will essentially be replaced by the land court. It signals a significant restructuring of how these land-related matters are handled judicially. Keep an eye on that one.
Good tip. What if Sarah and the owner want to avoid court altogether? Are there alternatives? Mediation, maybe?
Absolutely. The Act encourages it. Sections 21 and 22 deal with mediation and arbitration. Parties can ask the Director General to appoint a mediator to help them talk and find common ground. The LRMB can also help facilitate this.
Is what they say in mediation confidential?
Yes. Crucially, discussions and anything disclosed during mediation are privileged, meaning they can't generally be used in court later unless everyone agrees otherwise. It encourages people to speak openly.
So ADR alternative dispute resolution is built in.
Very much so. It's seen as a vital step, often the prerequisite the court considers, before even granting an eviction order under Sections 10 and 11. They want to see that attempts were made to resolve it amicably.
We said the act has teeth. What happens if someone just ignores it? Evicts someone without a court order?
That's a criminal offense. Section 23 is clear. Evicting someone unlawfully without that court order can lead to a fine or even imprisonment for up to 2 years, or both.
Serious consequences.
Yes, and it's also an offense to obstruct officials or mediators doing their jobs under the Act. And here's another powerful tool.
What's that?
If the public prosecutor decides not to prosecute an illegal eviction, the person who was evicted actually has the right to start a private prosecution themselves. That overcomes a big hurdle victims often face.
Wow, okay. And if the farm is sold, does Sarah suddenly lose her rights because there's a new owner?
No, that's covered by Section 24. The rights an occupier has under this act are binding on any subsequent owner or person in charge. Her security doesn't disappear just because the title deed changes hands. That ensures long-term stability.
What if an owner tries to get Sarah to sign an agreement saying she gives up her rights under the act?
That agreement would be void. Section 25 is very protective. An occupier cannot waive their rights under this act unless the act specifically allows it or it's part of a court order.
So those agreements don't hold water.
Courts have to consider such agreements, but they are not bound by them if they limit the occupier's rights unfairly. The Act's protections override agreements designed to undermine them.
But what if she decides to leave voluntarily?
That's the balance. If an occupier leaves freely and willingly, knowing their rights, they can't then turn around and demand to be reinstated. It protects against coercion, but respects genuine choice.
One last point. The Trespass Act. An older law. How does this act fit with that?
Section 27 clarifies this. This act doesn't cancel the Trespass Act entirely, but it states clearly that someone who has a right of residence under this act cannot be prosecuted or evicted using the Trespass Act. The Tenure Act takes precedence for those it protects.
Right, okay. We've really journeyed through the extension of security of Tenure Act, haven't we? From the history behind it,
The legacy of those past laws.
to the detailed protections it offers people like Sarah, the complex eviction process, the state support mechanisms.
It's a huge piece of legislation, really, a massive attempt to correct historical wrongs and create a fairer system for land tenure. It's all about balancing property rights with fundamental human dignity, trying to ensure people aren't just cast aside.
And it's not static. Those amendments, the upcoming land court, it shows this is an ongoing effort, always adapting.
Definitely. And for anyone listening, really getting those key definitions, understanding the layers of the eviction process, the role of those new bodies like the LRMB, that's crucial to seeing how this act works or is supposed to work on the ground.
So, here's something to think about as we wrap up. We've seen the Act provides really comprehensive legal protections, but we also know land disputes and tenure insecurity are still huge issues in reality. Beyond the law itself, what more do you think is needed to truly achieve that goal of long-term security and prevent unfair evictions in practice?
That's the million-dollar question, isn't it?
It is. Something for you all to chew on. Thank you for joining us for this deep dive into such a profoundly important piece of South African law. We hope you feel more informed and maybe even a bit more curious.